Ready, start. Former Supreme Court Judge Rumma Pal today tore into the process of appointment of judges to the Supreme Court and the High Courts and the lack of an embedded mechanism to ensure judicial accountability. Stop. Pal, a widely respected jurist, not known to mince words, choose to put a caveat to her words. Stop. She was speaking from the safe haven of retirement. Stop. Para. The process of appointment of judges to the superior courts was possibly the best kept secret of the country's top. She said judges' appointments are now initiated and cleared by a collegium of the four senior-most judges and the Chief Justice of India for the Supreme Court and three senior judges and the Chief Justice for a High Court. Stop. Since 1993, the executive's role has been to dutifully appoint those cleared by the collegium. Stop. The executive can return the names but has to appoint the judges if the collegium clears the list again. Stop. Pal said the criticism of appointments by the executive to the judiciary applied equally well to appointments made by judges to the judiciary. Stop. The mystique of the process, the small base from which the selections were made, and the secrecy and confidentiality ensured that the process may on occasions make wrong appointments and worse still lend itself to nepotism. She said. Stop. An indiscreet comment on a chance rumor was enough to rule out a person's perceived suitability for the post. She said. Stop. Friendships and obligations also sometimes color recommendations. She added. Stop. Consensus in the collegium is often arrived at by trade offs. She said with disastrous effects. Stop. Pal also lamented the growing psychopathy and lobbying which color these appointments. Stop. Para. These appointments, she said, should be done by a judicial commission of non-partisan members. Stop. Unless the process is made transparent and the resource pool widened and some objective criteria laid down, arbitrariness in appointments will remain. She said. Stop. Father of the human rights movement in the country, was a lawyer in the Bombay bar. Stop. He became a high court judge but later gave up the post to don black robes again. Stop. Tarkunde was never elevated to the Supreme Court because of extraneous reasons. Speakers at the lecture said. Stop. His landmark judgment that a person was entitled to a passport as a matter of right under Article 21 of the Constitution, right to life and liberty, was later adopted by the Supreme Court in the Maneka Gandhi case. Stop. Paul also listed several sins of the judiciary. See chart. Stop. She called for a judicial abandon strong mechanism to ensure accountability. Stop. Any non-judicial mechanism will impinge on the judiciary's independence. She said. Stop. The current solutions adopted by the judiciary, which give the CGI only the power to transfer or not allot work to erring judges, were inadequate and ad hoc. She said, stop.